Afternoon, everyone, and welcome to today's CLE in the annual meeting of the nonprofit section of the Georgia Bar. My name is Claire Oates. I'm the Assistant General Counsel at Boys and Girls Clubs of America, and it has been my pleasure and delight to serve as the section chair this year. And sort of the host of today's CLE and meeting. So first, I'm going to introduce our initial speaker, Anton Mertens, who's going to discuss the changing requirements around immigration compliance. Then we'll have a very quick section meeting. And then please do stay on for our second CLE, which is covering the executive orders from the Trump administration that have had the most significant impacts on nonprofits. If you all could please make sure that your first and last name are showing accurately in Zoom, that will help us take attendance, which will be used for CLE credit. You're not going to need to file anything additional. The bar will handle everything, but we need to make sure we have your identification accurately noted. Thank you. And now it is my pleasure to introduce our first speaker, Anton Mertens. Anton is of counsel in the Global Mobility and International Practices of Arnold Gold & Gregory. For over 30 years, he's assisted corporations and individuals from around the world in crafting immigration solutions. He has experience with all types of immigration matters, including business visas and immigration options for large and small corporate clients, investor visas, and green card applications, as well as permanent resident applications, green card renewals, and naturalizations for individuals. Anton was born and raised in Brussels and came to America as a high school exchange student. He became a U.S. citizen in 1994 and is passionate about helping others immigrate to America. Welcome, Anton, and thank you so much for being here.
Thank you, Claire. Good afternoon, everyone. We have a lot to cover. I will go ahead and share my screen, and we'll get going on our immigration compliance and enforcement, which I'll need to know, obviously. Let's see. Do you see my screen at this point? Let's see. Let's see. Looking at sharing the correct screen here. Let's see.
You had it, but it just went away.
It went away? Okay, let's see. Let's see where it is. Okay. Here.
Yeah.
Do you see it?
Yes.
Okay.
Just put that one in presentation mode, Anton, and you'll be good to go.
Yes, I'll do that. Here. All right, super. Well, let's get started. Got lots to cover. Obviously, this is what nonprofits need to know, but probably everyone else as well. We're all familiar, I hope, with Form I-9. If you're not, then give me a call later. We have to talk. But anyway, because of the Immigration Reform and Control Act of 1986, back during the Reagan years, all employers now are supposed to fill out these I-9 forms, which basically checks your employee's ability and authorization to work in the U.S. So it's not just for immigrants, it's for everyone who is an employee at your nonprofit organization. The employee has to fill out the form basically first day of work or sometimes before the first day of work. And then the employer, you as a nonprofit, have 3 business days to check, to verify the documents really the employee will submit to you. And so you have 3 days and to do that, to really look at the original documents initially, and I'll talk later about some change in that original documentation requirement. And again, Section 1 is there for everyone to see. The I-9 has had many iterations over the years. This is the most current one. It is actually has the expiration date is May 31, 2027. So that's the one you need to be looking at for any new hire. Obviously, you may have older versions for folks that are working for you currently. So it needs to be filled out. Section 1, employee Section 2, employer, list A, B, and C documents, or on the back of the I-9. Again, it's one list A or one list B and C document. And then you need to sign and date. Make sure you do that. I can't tell you how many clients I've audited or I-9s I've audited and realized that there are a lot of paperwork violations where maybe it wasn't signed or wasn't dated. And even though there's one on file, it is not in compliance and could get you some fines over the years. Certainly, the larger you are, the bigger the fine, unfortunately. Now here on the re-verification and rehire section, there's now a checkbox that says, check here if you use an alternative procedure authorized by Homeland Security to examine documents. And I mentioned previously that you had to verify documents in person, but that has changed, thank goodness, thanks to COVID, or maybe despite COVID. But there is a virtual verification available now. And that started in 2023, August 2023, and where you can actually virtually inspect documents rather than having the person standing in front of you. Now, obviously, not everybody is qualified to do this. Number one, and in Georgia, that's not necessarily a big deal, but you should be verified. You should be enrolled in E-Verify. Obviously be in good standing with E-Verify. Don't really know what that means. Means you're using it correctly. Although there again, I've audited many employers who say, well, gosh, E-Verify wasn't working that day, and I never went back and registered this employee, 2 years ago. So what do I do now? And then, they obviously don't know if they're in good standing, but they haven't been fined or really been notified by E-Verify that doing it incorrectly. Anyway, so gotta make sure you're enrolled in E-Verify. Again, you have to fill out the I-9. E-Verify is separate from the I-9, but you got to be enrolled to be able to use this virtual verification. Now, you have to do the training, of course, make sure you're aware of any fraud and anti-discrimination issues. And then what happens is, if you're in fact allowed to do this virtually, the employee will send documents to you, scan, email a scanned copy. And again, there as the employer, you're supposed to look and make sure the document appears to be genuine. Keep in mind, you're not a document fraud expert. So don't, sometimes folks stressing, what if it's a fraud? What if it's a fake? Well, if it appears to be genuine and relating to the person standing in front of you or the person you're hiring, make sure that the birth date coincides with the birth date they gave you. And then, of course, you do a live video interaction with the employee online, a Zoom or Teams meeting, and then, kind of play the game, so to speak. And then when the game is over, the employer can check the box saying that, yes, in fact, I used the alternative procedure. And, then, of course, at this point, as an employer, you're supposed to keep the documents that were emailed to you, and they become part of the I-9, so to speak. And I get lots of questions about, well, should I copy documents when someone comes in with their documentation in person? And I usually tell folks, no, there's no requirement you do that. But if you do it, be consistent. Make sure you do it for everyone, not just, folks that maybe not look American for whatever reason you think they may not be legal, or you have a question about their nationality or about their employment eligibility. You should do it for everyone or for no one. Obviously, with this virtual verification process, there you do have to copy the documents and they become part of the I-9. So again, don't fret too much. Make sure whatever you do is consistent in the process. And then again, as an employer, if you only have one location, and folks come into the office, you don't have to use the virtual verification. It's up to you. But it does help employers with multiple locations throughout the state or throughout the country, for that matter. So in the past, you had to send someone to verify in person. Now it can be done virtually, and that is certainly a benefit. I guess thanks to the COVID pandemic. Again, if you're going to do it, do it for everyone, at this alternative site, meaning not your headquarters. And again, when you do it, keep the evidence with the I-9, make sure it's been done in case you ever get audited. And those audits probably are coming. There was a time where, I guess in the previous administration, where we just never heard about I-9 audits, never heard about ICE coming to the workplace. Obviously, that has changed since January 1st. Everybody is on high alert, so to speak. And so ICE comes in for a variety of reasons. One of the reasons may just be because they're looking for someone. They have a warrant, either administrative warrant or judicial warrant. We'll talk about that. But they're looking for someone in particular. They're not just, fishing, so to speak, or they're not doing an I-9 audit. They're looking for someone who has a deportation order or a criminal warrant, or someone that they want to put into custody. So that is one way. Of course, another thing is if you're an employer who is kind of in the crosshair, so to speak, hospitality industry, construction industry, those areas are ripe for I-9 audits and ICE audits in general. So be careful. As a nonprofit, again, it's kind of hit or miss. My question has always been, well, that's great, have more enforcement and more compliance, but who's going to do it? Who is going to show up? What I-9, what ICE agents are going to show up and do all these I-9 verifications? Hard to tell at this point. It's happening, but it seems to be focused on folks that they're looking for at this point. Of course, if you're there, you may be getting caught in the in the ICE audit or in the ICE raid. Really, the ICE has the enforcement and removal operations. Again, those are the folks that are looking for undocumented immigrants, folks without any kind of documents to prove they're here legally. And then there's also Homeland Security investigations. And those are the folks that come and when you hire someone on a visa, whether it's an H-1B or an L or an E, they come in and check and make sure that this person is doing the job that you said they were doing, that they're a manager, or that they have a specialty occupation, and that they're not just doing manual labor on this visa. And again, that's a different group. So if you don't have any foreign employees, meaning sponsoring folks for visas, for work visas, Homeland Security may not be, knocking on your door. It'll be mainly ICE and ERO folks. Again, most of those operations happen within the U.S., and they're going to coordinate, especially now, with state and local enforcement agencies. That's the county sheriff or a state patrol, whoever is available. And again, they are really enforcing immigration. This has been a focus since 9/11 because it's a matter of public safety. Obviously, we've seen that since January, things are a little more taken a little more seriously when it comes to enforcement and compliance. So make sure that you are in compliance. I-9 audits are the typical tool for ICE, for Immigration and Customs Enforcement, to make sure that you as an employer are doing it correctly. And unfortunately, as I've mentioned previously, most of my audits that I do show lots of deficiencies, and the workforce may be completely U.S. citizens. It's just still the I-9 has to be done correctly in a timely fashion. Again, the I's have to be dotted, the T's crossed, and there certainly is a right for I's to come in and verify that you're doing it correctly. What happens is you get a notice of inspection, and then they come in and say, well, give me all your I-9s and a list of all your employees. Keep in mind, as an employer, you have 3 days to comply. So don't have a knee-jerk reaction, say, oh gosh, I want to comply, I want to be a good citizen. Here are all my I-9s. First thing you do, of course, is call your attorney, person who does your workplace compliance, whether it's employment lawyer or an immigration lawyer that you have on call, and make sure that the I-9s are in order. Of course, it's a little late. You're not going to, if there are lots of deficiencies, you're not going to have a lot of time to correct those. I mean, talking about 3 days. But anyway, ask for the 3 days. Sometimes you can ask for more time. If it looks like, gosh, you have several locations that you want to, coordinate, it certainly doesn't hurt to ask them for a little extension of time. And especially as an attorney, sometimes you can get them to do that. Again, I would use every day possible to make sure that everything is in order. And even if you do have to correct things, again, you can't backdate stuff, but at least you're showing willingness to be in compliance, and your fines, if any, may be significantly reduced. So I-9, I mentioned, is certainly one of the things you do. If you have folks on site in your workplace that you sponsored for a visa, whether it's, again, as I mentioned, H-1B, special occupation visa, or L-1, intercompany transferee, they may talk to those folks separately. I've had clients call me in the past and say, oh gosh, somebody from immigration came by and talked to Jane, our HR manager, who's from Germany. And so they spent time together, and obviously they were satisfied that she was doing the work that you said she was doing. So be careful. They're out there, and they'll come and make sure you comply, and that these folks are in the position that you said they were going to be in. Immigration rate is a little more, is different, probably. Again, you're looking for someone in particular. In this case, now recently, undocumented. There's been a lot of focus on the Venezuelan gangs, the Mexican gangs, just folks that either have deportation orders or have criminal warrants outstanding. They'll be looking for those folks at your work site, if in fact there is a tip or an indication that they may be there. If that's the case, then everybody's kind of fair game. Sometimes people wonder, well, how am I targeted for an I-9 audit? Maybe your competitor says, hey, ABC company is using all these illegals. I can't compete with them, or they're undocumented and they don't have I-9s. Go check them out. Or someone gets fired and says, gosh, there's a bunch of illegals over there, or they're not doing the I-9 correctly. Again, another tip, something that's, or a complaint, sometimes trigger this I-9 audit. Again, these audits have to be staffed, so not sure where they're going to get folks, doing these audits, but they're out there. And then, of course, the Department of Labor is also a source of these audits, or Social Security. You've heard of the mismatch letters. If there's a lot of those, Social Security may say, well, you may want to check out that company over there. Or if there's a lot of Department of Labor complaints, then may say, well, let's as part of that Department of Labor investigation, let's do an I-9 audit at the same time. So what happens is when an immigration raid happens, again, not typically an I-9 audit, they'll have warrants more than likely, and they'll be asking to talk to folks. They probably have a list of folks that they want to talk to. I think just recently, I have a client down in South Georgia, and there was, apparently immigration enforcement was happening down there, and that, it was a small town, And that traveled very quickly. Matter of fact, my client told me the next day only about a third of the employees showed up to work because they were worried that somebody was after them. Now, I guess they're back at full force now, but when that happens, when these audits happen, especially in smaller communities, that news travels fast, and folks run scared, obviously. But again, it's targeted to these folks, as I mentioned, hospitality, like restaurants, hotels, construction industry, cleaning. Gosh, the folks that do that clean businesses and clean offices, they are certainly targets as well. And then, in the agricultural business, there are lots of folks there that may or may not be authorized to work in the U.S. So those are targets for immigration raids. Now, what about, can they just come in and force their way into the office? There is the Fourth Amendment, obviously, and certain places are protected. And so the question then becomes, where can they go? And again, ICE always has the right to enter public areas. So your parking lot, your lobbies, your cafeterias that are part of the business, waiting rooms, all those are public areas. Now, obviously, showers or special locations, businesses that have obviously information that is sensitive. Again, those areas cannot be looked at, and certainly you would not be able to enter that even with an ICE person coming in saying, "Hey, I want to look at this." So the issue with public and sensitive locations or protected areas has changed a bit recently. In 2011, there was a limit to where you could conduct arrests, and certainly you could not, or there were certain guidelines on sensitive locations, and of course those were schools, obviously churches, religious buildings. Those areas were sensitive, and then in 2021, again those protections were expanded, and they were protected. They were referred to as protected areas, or private areas, so to speak. Then in 2025, this year, earlier in January, executive order came in about policy that ended restricting enforcement near those protected areas. So Homeland Security will no longer recognize those certain areas as protected, and basically then, can you go into hospitals, schools, churches, and take enforcement actions? So there is that. We're waiting, I guess, for more guidance on that, but it looks like that authority is there, and they will come into those sensitive places and private areas, so to speak. Now, as an employer, you're certainly looking at, well, how can I protect my private spaces? Do I put private on the door? Certainly, you could do that. Then you worry about, well, what about my break rooms that are just for employees? Are they public or not? And more than likely they're private because public off the streets not coming into your break room. Then you look at hospitals. How far can they go? What about examination rooms? What about nursing stations? Same thing with schools. Can you come into the classroom or the cafeteria or wherever the public is allowed or is not allowed in this case, because schools are certainly sensitive areas. People just can't just walk around in schools. And so that's, and churches, again, there's been a lot of publicity about ICE coming to churches and folks being worried about not being protected by the church door anymore. So now, how can you limit ICE's access? Again, with a warrant, again, administrative warrant, they can come in to public places. Again, make sure where you make the difference between public and private place. So an administrative warrant is only for public places. Obviously, if they have a judicial warrant, it's a different story. And how did it differ? Well, administrative warrant is not signed by a judge. It's typically just a warrant from DHS, again, looking for a particular individual, someone who's here either unlawfully or maybe has violated immigration laws or criminal laws. But still, the administrative warrant does not allow the ICE agent to enter those private places. And again, as an employer, you have a right to refuse entry to those places as well. Judicial warrants, those are different. Those are signed by judges. They are really, they're no holds barred. You can go anywhere. And again, as long as the area is specified in that warrant, it's not a carte blanche. And you have a right to refuse entry if you want to. If in fact, I would not stand in the way, but if something like that happens, I would keep a good record of what's happening. Certainly, you want to see the warrant, get names of folks that are there to, just conduct a search and make sure that the areas that are covered in the warrant are the areas that they're looking at and not other areas. It's not open door to all areas. It's whatever is specified in that judicial warrant. So what's been happening and since January? How's the landscape different? And certainly we're in an era of enforcement, and with it goes compliance. But the focus of the administration currently has been folks that are here without documents, that have criminal records or criminal histories. Certainly, folks with pending deportation orders. You see about that on the news just about every night. And then they're also looking for folks who are not authorized to work here and are working, in fact. And then just anyone who's undocumented, which could be, 10, 12 million people. Again, a lot of folks. If the goal is to remove or deport, about 100,000 people a year, or 10,000 a month, let's say, it's going to take many, many years before everyone is removed or everyone has been contacted. So now the question becomes, as I mentioned, well, who's going to do this? Who's going to do this enforcement? And it's not just ICE. You've heard about military being involved in that as well. Again, to enforce the laws, but also the border. Obviously, the border has been an issue, at least the last 4 years. That is being, remedied. I mean, I guess the current administration is talking about very few people are crossing the border illegally. We've had very few apprehensions. So one of the goals was to make the border secure, and certainly doing that. Again, as I mentioned here, they're hiring more contractors. Maybe some of the folks that got laid off and some of the federal jobs could apply, but at this point, they're in full force targeting, I guess, the folks with records first, and then it'll trickle down to everybody else who is here without permission, so to speak, unlawfully. So how do you prepare for a visit? Should you be worried? Well, what should you do? Obviously, you shouldn't make it up as you go along. You should designate, the company should designate, your organization should designate a point of contact. Someone that, if someone comes knocking, who to contact. Call so-and-so. This is the point of contact for this location. That point of contact should be the interface with the agents, and they should ask for IDs, details on what are they there to do. Are there any warrants? These are warrants. What are you And is it a judicial warrant? Is it an administrative warrant? And so make sure that this point of contact knows what to do and what not to do, more importantly, when someone comes knocking. Again, I-9 audits are certainly not as confrontational. Again, use your 3 days. Don't provide documents right away just because they ask for it. I-9s actually, you have 3 days to comply with the request for the I-9s. Make sure that if it's an administrative warrant, that folks do not enter private places, that it's, again, they're limited to public places. And there should not be, they should not be going into private places with these administrative warrants. If it's a judicial warrant, obviously, then you got to look at what are they, what's the warrant about, what spaces can they enter, and what is set out on the warrant, to in fact go seize evidence or go maybe look for someone or look for a particular item in the warrant. That point of contact should also be trained on how to interact with ICE. I mean, certainly when someone is there with a warrant, it's confrontational. Certainly, folks should be, should know who to contact. And in this case, if there is an ICE audit or in any interaction with ICE, I would say I would certainly at the point of contact should have someone, that they could call, an attorney who could be there quickly and interface again with these ICE agents. Agents may want to question certain employees. Again, as an employee, you don't have to answer. You can take the fifth. You can, again, as an employer too, you can say, well, my employees are working, they're on the floor. All you have is an administrative warrant. I'm sorry, you can't talk to them, and just may have to wait outside until they get off of work or something. But there again, as an employee, obviously, if you have nothing to hide, you could decide whether you want to talk to ICE or not. Again, there are all kinds of what to do when ICE comes knocking, pamphlets out there. I would say, make sure you have some of those available. What are my rights as an employee? What are my rights as an employer when there is interaction with ICE and who come in either for I-9 audits or to look for someone in particular. Obviously, it goes without saying, your employee and you as an employer should always tell the truth. Things go from bad to worse if you lie and fraud is committed. Then you could really get arrested. Now, as a company, as a nonprofit or even a profit for-profit, I would certainly say in this day and age, it is time to conduct internal audits, I-9 audits, E-Verify audits as well. But I'll focus here on I-9 because you're dealing with ICE. Again, when ICE shows up, make sure that the employees know who to contact. It could be that it's the work is outside, for instance, on a work site, and they're being interrogated or at least being talked to. I think your employee should know, who to contact. And again, whether or not they need to speak to ICE. And so if there's a raid, certainly you should have legal advice because you don't want things to go from bad to worse. And then if folks do get arrested, you could certainly provide counsel to them, and more than one person can be represented by your attorney, by your company attorney. And again, it depends on what it's about. It depends on what the investigation is about. You may need a criminal lawyer if it's a criminal investigation, or if it's just, speaking to them about something. Again, they have a right to not talk to folks and not incriminate themselves. during these audits. Now, what if you don't comply? There are penalties, there are fines. And that's, I get that a lot from HR departments. And so, what's my liability? Can I go to jail? Well, yes, you could. But more importantly, what the government is looking at is fining you to I guess make sure you don't do this again in the future. And I mentioned paperwork violations several times because at the end of the day, that could add up. I mean, you look at paperwork violations, $281 to almost $2,800 per paperwork violation per I-9. If you have 100 I-9s that are not in compliance, you're looking at $28,000 pretty quickly. $280,000. So I would certainly say make sure that they're in order, because some of these things you can remedy even if it's late. You could remedy, show good faith that you want to be in compliance. Now, the problem becomes when and I talk to clients sometimes, employers sometimes say, well, gosh, I know there's a couple of folks and they're managers and they're good folks and they've been with us for many years, and I know they're probably not here legally. What do I do? At that point, as an employer, of course, you have knowledge. When you have knowledge, when it comes to be a knowing violation, then the fines go up tremendously, as you could tell. And if you don't have an I-9 on someone, and that someone ends up not being authorized to work, that is a knowing violation. So besides the paperwork violation, it is also a knowing violation, which again is much more expensive. And they'll look at your past. I mean, have you been audited before? Have you been fined before? How big is the business? How many I-9s were deficient? How many folks? We sent a list with folks that are not authorized to work. Did you in fact take those folks off the payroll? And then, how many of your folks were in fact not authorized to work? And again, folks come in with false documents, sometimes even with E-Verify. Sometimes you could fool the system, and you as an HR professional may have done everything that was necessary and done everything correctly. If ultimately that person is not authorized to work, you may not have any liability. Again, as long as you did what was supposed to be done, as far as workplace compliance is concerned. Again, some of these other criminal consequences, you sometimes hear about those when when those happen, ICE does publish them on their website. They'll talk about them. Again, they'll scare other employers to make sure they're compliant and that they're that they're doing what they're supposed to do and not harboring illegals, not knowingly employ folks that are not authorized to work in the U.S. So again, some of these are somewhat outlandish. Now, having said that, FEMA had just sent out a letter to a variety of providers of services to say, hey, if you're dealing with, if you're helping or assisting with folks that are here legally, we may not give you your funding. So send us a list of everybody that you're dealing with. And so, there are things happening out there that are serious and that are, to me, are problematic. Talking about undocumented workers. I mean, you may not know someone is undocumented. They may be working for you with false documents. So I'm not sure how that will be carried out, and will there be more guidance for companies? Making sure that you don't get in these in some of these more serious consequences, criminal consequences. And then, of course, if you have an ICE investigation, then kind of it's the beginning. It's the beginning of things. Other things can happen. OSHA can come in. You may have a FLSA issue, or maybe not reporting taxes correctly, or not doing things right. So you want to make sure your I-9 documents are in order, because if those are not in order, then government may say, well, gosh, if this item is not taken care of, maybe there's other things. So let's go ahead and investigate further, bring Department of Labor, bring OSHA in. Again, it's the beginning of bad things, unfortunately. Some examples. I mean, obviously, IFCO, big company, pallet company, they had worksite enforcements at 45 of their locations, and almost 1,200 people were detained, and they were undocumented and not authorized to work in the U.S. And so, obviously, the folks that were in charge of hiring those folks and maybe not verifying them, they were fined. They pled guilty, and 5 senior managers actually, and so they knew that they were doing this wrong, and they didn't care. So at that point, they were fined, and so there were consequences on the lax treatment of those employees. Other one is Uline. Just saw a Uline truck the other day. They were doing it differently. They were basically, and you hear about that sometimes. Some of these IT companies get caught. They bring folks in as visitors. They're business visitors, which is a B1, by the way. B2 is a tourist. So you could be a business visitor or a tourist, and they bring them over and put them to work. And you can't do that. You have to have a work visa to work in the U.S. So sometimes folks come in with these business visitor visas. I'm engaged in business activities, but yet they're building a plant, or they're doing work, and they stay whatever the amount of time they're allowed to stay, 3 months, 6 months, and then they go back and shuttle people back and forth, and then they're not being paid in the U.S. They're being paid abroad. So there's no scrutiny there, but these folks were caught as well. And you'll read, if you go on the ICE website, they enjoy posting some of these things out there. So, oh, this so and so got caught, and there are so many fine of so many thousands of dollars, or people pled guilty. So again, important to do it right, and to be serious about it as well. What's going to happen in the future? We're just starting out, so to speak, with Trump 2.0. There are lots of question marks. As an immigration attorney as well, it's kind of like a moving target. Things change day to day. Talking about registration. Oh, what does that mean? Talking about travel bans. What countries? So who knows? I mean, enforcement is a number one priority of this administration. That means, making sure you're doing it right. Is the state going to come in? Is it going to be really only federal? What about locally? Again, you need to make sure that your records are in order when it comes to your I-9s, and make sure you hire only workers who are authorized to work in the U.S. So what will happen with folks once all the criminal folks with criminal warrants, or folks with deportation orders are removed? Who's next? People talk about, well, there's an ICE raid. They were looking for people, and some other folks got also caught up in that dragnet, and suddenly they find themselves, being ready to be sent somewhere else, out of the country. So again, as I mentioned, registrations coming in. I've already gotten several questions about that from clients. I said, well, I came in on this visa. I got my I-94. Do I have to register? Have I already been registered? So be on the lookout for more information about that, soon, certainly. And again, more of that will be in the future. So what are you supposed to do with all this I-9 stuff, with this compliance stuff? Be diligent. Make sure you have a list of all your employees. Make sure that those employees all have I-9s. Also, I tell folks, don't keep your I-9s forever. Every so often you need to purge stuff. basically the I-9 is kept for everyone, of course, who's working there. And then once someone is fired or terminated or leaves, you can keep your I-9 for a total of either 3 years from the date they were hired or 1 year after termination, whichever is longer. So if they've worked for you for a year and then they leave, you got to keep it for 2 more years, total of 3 years. If they've worked for you for 4 years and then they leave or get terminated, you have to keep it for 1 more year, so a total of 5 years. So, but make sure you purge those things, because even the old I-9s you're not supposed to have anymore, they could, they could be part of an investigation, and certainly could make things, could be an aggravating factor if there are lots of those that are not filled out correctly. Again, they'll ask you, an I-9 audit will require a list of current employees and also maybe past employees. But when you have an audit, I would say it goes without saying that as an employer nowadays, you should do an internal audit. Make sure it's been done, recently or within the last year or so, and then find out what's wrong. Are there deficiencies that keep coming up on I-9s that could again be construed as workplace, as paperwork violations. E-Verify, as an employer in Georgia, after 10 employees, you're supposed to use E-Verify, or if you have a federal contract. So make sure that's in order as well. And again, that's separate from I-9, but is also a matter that needs to be considered, and make sure that you do it correctly. That, don't keep someone on the payroll if there's a final non-confirmation, or if there's a tentative non-confirmation of their Social Security number. Again, that E-Verify system is based on Social Security numbers. If there's a tentative non-confirmation, make sure that the employee knows there's an issue. Go ahead and take care of it and report back to me. Don't ignore those things. Again, E-Verify is another trap that could sometimes bring you in trouble, get you in trouble. More E-Verify. Again, now, if in fact you are a company that does hire foreign workers and sponsors them for, or petitions for them for certain work visas, make sure you have that documented as well. Homeland Security will come looking every so often to make sure that records are kept correctly. Make sure that folks are in fact working in positions that they were petitioned for. So with H visas especially, there are lots of regulations. You can't bench someone. You got to pay their prevailing wage. You got to make sure you have a labor condition application on file for them. You have to make sure you have a public access file. All these things that are required when you're going to sponsor someone for a visa. And that's going to get more complicated as well. Enforcement is one thing. The thing that goes hand in hand with that is scrutiny. We already see it in embassies and consulates abroad, where folks really are getting scrutinized a lot more heavily, either because they may be on a watch list, or maybe their name is similar to someone on the watch list. And then you get this administrative processing where folks get, oh gosh, can't get you a visa. We got to make sure you're not a bad person. And that may take several weeks. So that is happening now. Sometimes harder to get your petition approved. We routinely get requests for evidence for cases that should be approved, even for cases that are seem to be just extensions of a current status. Nothing has changed, but yet you get a 10-page request for evidence from the Immigration Service to make sure this person is in fact authorized, to work in that position and has the necessary background and educational background or professional background. Immigrant visa matters. There again, if you are an employer who sponsors employees for green cards, for permanent resident status, there's a lot more that comes into play there. When you test the market, are you doing it correctly? If you're doing labor certifications, again, you got to keep files. The Department of Labor is involved in that, but also immigration. So make sure that again, you're compliant, you keep up with it. You have someone who's trained in that, and make sure you keep good records. I think is the most important part of what we've been talking about so far is do it right, keep good records, verify your records, and if in fact there is an audit, make sure you know where to go to get those records. Make sure they're compliant, and do what's supposed to be done. Um, you know, Something that we haven't seen recently, but that may come back, is these no match letters. A while back, it's been 8 years or so since those were, maybe less, but since you got these batches of no match letters. People say, what do I do with that? Well, just whatever. Just don't worry about it. That means some social security numbers don't match names, and they're working at your location. So that is something that may happen again. You know, just as a general observation, immigration is getting to be a lot more difficult. I mean, for many years, the Immigration Service is not interested in interviewing folks anymore for certain benefits. For instance, when you get a green card, you marry a non-citizen, marry someone from a different country, and that person gets a green card. If it's a marriage-based case, you could count on an interview at the local field office. Then COVID happened, and the Immigration Service said, "Whoa, we don't want you to come to the office anymore. Stay away. We'll if we need more information, we'll let you know." And at some point, a green card shows up in the mail, or whatever benefit shows up in the mail. That may change again. I've just seen several notices for interviews. Actually, I've seen notices for interviews of folks that had gotten the green card last year, and now they're being called back in. What's up with that? What is there something wrong? Did I do something wrong? Is my client not eligible for that benefit? So again, you try to comply. Make sure you have good counsel in helping you. Some companies sometimes seem to be flippant about that. So, well, whatever, I'll deal with that later. I got other things I got to do. These things can actually be very, very punitive at the end of the day. And you don't want to be on the radar of ICE or any government agency for that matter. So, with that, I do want to end my presentation. Certainly, we realize that we're now in a atmosphere of compliance. Well, enforcement first, but compliance second. So make sure you do what you're supposed to do. Make sure you comply, and when enforcement shows up, make sure you know how to call when it comes to folks being after your employees or after your records. Again, you want to make sure you do it right, minimize your exposure and your liability.
Thank you so much, Anton. I don't see any questions in the chat, but that was a really helpful, comprehensive overview of a subject that I suspect many of my fellow nonprofit practitioners don't have a lot of familiarity, but very much need to, given the changing circumstances we are all in now. So really do appreciate your time and your expertise.
Certainly. Absolutely. Glad to do it.
And with that, I will close the annual section meeting and move on to the introduction of our next speakers, who are going to talk about the most significant of the very many executive orders coming out of the Trump administration and their impacts on nonprofits. First, Mindy Simon is Deputy General Counsel at Emory University, focusing on taxation and corporate matters. Prior to joining Emory's Office of the GC in August of 2004, Mindy practiced as an attorney in the tax section of an Atlanta law firm, where she specialized in general federal taxation and the representation of tax-exempt organizations. Mindy received her BA from Rhodes College and her JD from the University of Tennessee. Jonathan Poole is an associate general counsel, also at Emory, focusing on litigation, education law, and employment law. Prior to joining the GC's office at Emory, Jonathan was a partner at Strickland, Brockington Lewis, heading its educational and employment practices. He received his undergrad in economics from UGA and his JD from Georgia State. Jonathan has served as the chair of the school and college law section of the State Bar of Georgia and is a member of the National Association of the College and University Attorneys. He is also, as of 5 minutes ago, the newly elected chair of this section, so we are very lucky to have him here on this auspicious day. Jonathan, congratulations, and I will hand both the chairmanship and this CLE over to you. Happily. Thank you.
Thank you so much. All right, let me share my screen here. All right. Get up the presentation form. There we go. All right, so thanks everybody for joining us today. So there's a lot going on. If you're like us trying to keep track of everything that's going on, especially the executive orders, can be a little bit overwhelming. But we're going to try our best to kind of break down the more consequential executive orders that we've been dealing with lately. And please, if you have any questions, just drop them in the chat and we'll try to get to them. All right, so kind of a roadmap for today's presentation. All right, we've got an overview, going to give you an overview of the executive orders and other executive action affecting nonprofits. Hopefully give you some insight on legal and operational impacts and some practical guidance for navigating compliance in a shifting regulatory landscape. I think a lot of this was actually existing law that we have to just ensure that we're compliant with, but there certainly is more of a focus on certainly the DEI aspect of it that requires some really close attention. And so we'll try to give you some tips on kind of how to get your arms around what you might need to in your own nonprofit space. All right, so let's talk about what an executive order is, because you hear that term a lot, and I think it can be a little bit confusing. So an executive order is signed, written, and a published directive from the president, right? It's published in the Federal Register. They have the force of law, but are not laws. It's much like a regulation issued by federal agencies. They direct and manage the executive branch of the federal government, which includes federal offices, departments, and agencies. So a lot of the executive orders are directed towards taking some sort of federal action related to a federal agency. However, private sector companies are not directly subject to restrictions or requirements imposed by executive orders, but may be indirectly impacted if they work with or receive money from the federal government, which I think a lot of us do. All right, so the first executive order we're going to talk about is Executive Order 14-173, ending illegal discrimination and restoring merit-based opportunity. All right, so very broadly, what the executive order did was it rescinded the previous, an executive order EO 11246, which had been on the books for decades and contained the non-discrimination requirements and its related affirmative action obligations regarding women and minorities. I think there was a lot related to this executive order that was kind of up in the air, but what was clear and what the administration clearly had the power to do was to revoke that previous executive order. And that's really where all of our affirmative action requirements flowed from, related to women and minorities. And the executive order gave a kind of a safe harbor provision where federal contractors had to come into compliance within 90 days, which is rapidly approaching, which is April 21st, 2025. We'll talk about that a little bit later. It ended the investigation and enforcement of that same previous executive order. So OFCCP lost a lot of their workforce, and they were told to they stopped enforcement actions that were based on the previous executive order. And it was my understanding that they paused the ones related to veterans and disability, although I don't know if they've started those back up again. And the executive order also identified new areas of focus on DEI initiatives in the private sector and higher education, and directed each federal agency to identify specific targets over the next 120 days. We've seen some of those rolled out already, and they'll start to we'll start to see more of those over the coming month. What hasn't changed with the new executive order and the rescission of the previous executive order? An executive order cannot change existing federal law, right? So it hasn't changed the existing federal non-discrimination law. So we're still the law for under Title VII, the Equal Pay Act, the ADA, ADEA, Section 1981, Title VI, all of those are still in effect. Notably, that includes non-discrimination, non-harassment, and anti-retaliation obligations regarding race, color, sex, gender, sexual orientation, sexual preference, pregnancy, religion, national origin, and age. The requirements of VEVRA, which protects veterans, and Section 503 of the Rehabilitation Act, and that protects individuals with disabilities, remain. So while we no longer, if you were subject to the affirmative action requirements in the previous executive order, while those are with respect to minorities and women, you no longer have those obligations. You still have obligations to do so with veterans and disability, because those were set by statute. So you still have utilization goals, and you still have hiring benchmarks. And that also didn't change the reporting, the EEO-1 reporting requirements for race, ethnicity, and sex. Mindy, you want to take this piece?
Yep, Jonathan and I are going to bounce back and forth on these, and maybe both do some of the same slides as well. And I think what's really important when you're thinking about this, and this is where our clients get all confused, is that you have affirmative action, and then you have all this conversation about illegal DEI, and we're going to talk a lot about that. But it is very clear that with regard to the affirmative action provisions, that those need to change, and those need to change in your contracts and websites and other places, and that you only have a few more weeks left to do that. So that's something to really focus on at this point. What this executive order also said, so in addition to changing the language around affirmative action and rescinding the previous executive order on affirmative action, is that if you look at this section from the executive order, and I think it's actually 3B4A, is that they were requiring each agency to include in every contract and grant a term requiring the contractual counterparty or the grant recipient to agree that its compliance in all respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for purposes of Section 3729B4. Why is that important? Okay, let's go to the next slide, please. Well, actually, I'm going to tell you why that's important in a minute. The next slide, this slide says that the head of each agency shall also require that a term that requires counterparties or recipients to certify that they don't operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. So they have a materiality statement and then a statement that they're going to be including in grants and contracts saying that there's no violation of DEI laws. And what that's doing is it's setting up False Claims Act potential claims for these grants and contracts with the federal government. So the elements of a False Claims Act claim are that it's a claim that defendant has submitted to the United States. So if you have a grant, if you've got a contract and you're submitting a payment request to the federal government that was materially false or fraudulent. So if you go back to that slides to the first slides 1, 2 ago, where here they said that it was that this is going to be material to the government's payment decision. So they're setting these up for False Claims Act claims. All right. And then third, the defendant's conduct was knowing, so defined as actual knowledge, reckless disregard, or deliberate ignorance. So why is this a problem? Well, There are a couple reasons, but the big ones are these first two. One is that these are treble damages. So it could be recovery of 3 times the amount of actual damages which the government sustained per payment. There can be a civil penalty imposed between $14,000 and $28,000 per claim as well, regardless of any damages sustained. And private whistleblowers are entitled to between 15 and 25% of the government's total settlement if the government intervenes. So this is setting up federal contracts around not complying with DEI in a way we've never seen before. So not only do you want to get the affirmative action language in place, then we also need to be concerned about DEI. And we're going to talk about that in just a few minutes as to what that means. Because one of the things that is unclear is what is this DEI? What is illegal DEI? What is fraudulent DEI? And all we have to go on right now is basically Title VI, Title VII, and Title IX of the Civil Rights Act and potential violations of that. And then we have some other executive orders later on that we'll look at and just talk about what the potential what we can glean from those as to what is potentially illegal DEI.
Yeah, and I think it's really what's nerve-wracking or worrisome about this is it's a little vague, right? So are we going to be required to say that typically a lot of times when you have a term and a grant, it relates specifically to that grant, right? Or the program that you're talking about at issue. So it appears that, well, I mean, we'll have to see it as you start rolling in, but are you going to be having to attest that just everywhere across your organization is in compliance with federal law? And then just False Claims Act litigation is very expensive and it takes a while. So just the fact, I mean, this is likely to be a deterrent for some organizations, just the threat of litigation from really anywhere at this point. But we'll talk about what that's going to mean.
Can I say one more thing, Jonathan?
Yeah.
Can I say we have
Yeah.
not seen? So we have Emory has a lot of grants and contracts. We at this point have not seen these certifications in our grants. We have heard of some of them being rolled out so far. So there've been a few institutions we've heard of receiving them, and at that point it was really specific to the grant itself. So it wasn't specific to in that case, a university writ large. But we anticipate that there'll be other, if it's not in a grant or agreement, it will be in other agreements that the institution would have to sign that might wrap in the entire institution, all of any kind of DEI programs throughout the university in this case.
Yep. And so the third kind of big piece of that executive order we've been talking about is this enforcement threat. So each agency was asked to identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Just speculating why they did this is likely because when you've seen the cuts in the workforce in all of the federal government. So it seems like what we're starting to see are the administration is identifying their priorities and then going after it. There's fairly high profile investigations and just it's kind of constantly in the news. So that's that enforcement act threat is in that executive order as well. So, kind of what can we glean from this executive action? And there are a few other, executive orders. Seems like there's going to be a drastic shift in federal enforcement to focus on DEI. Now, every administration, when they come in, the administration, they have certain things they're going to focus on, and clearly DEI is one of these. the executive order, as we mentioned, required all federal agencies to enforce our longstanding civil rights laws and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. And what you're dealing with here now is not just the threat of having compliant programs, but really there's the threat of these investigations. And we've seen these investigations, and it seems to be moving. At least in certain aspects. So when you're talking about, so let's take the Office for Civil Rights. Typically, the way a process would work is to be a complaint filed or an enforcement action, a compliance review instituted let's say, a university, and that could take years, right? You get a notice of a complaint, you talk to the investigator, you set up a timetable to provide your documentation. And then it goes all the way down the line to where you potentially enter into a resolution agreement. But what we've been seeing lately in some of these in the news is you see there's an investigation opened, but at the same time, large, millions of dollars in federal funding is threatened to be withheld that may or may not relate to the issue that's being investigated. And what that does is it just moves it so much faster, right? And so it's not, I think we have to treat the threat of these investigations, because the threat is that it might get to this large chunks of your federal funding if you receive that. You have to view that investigation threat almost on par with whether or not there's some sort of legal action taken against you. And so there's much more scrutiny on your DEI efforts from many different agencies, right? I mean, it's the EEOC, it's OCR, Department of Labor, Justice Department. So what can we glean from the executive orders, and what is illegal DEI? Because that's what the title of the executive order is, and it's throughout. I think most of us would say we don't, I hope all of us would say we don't engage in illegal DEI. But what does that mean? There are a couple of different places we can get some hints about kind of what this administration would consider to be illegal DEI. There was an executive order on the screen here, EO 14185, Restoring America's Fighting Force. And in that executive order, it gave the definition of a DEI office. And as you'll see here, it talks about an office that's established for the purpose of influencing hiring or employment practices at the institution with respect to race, sex, color, or ethnicity, other than through the use of colorblind and sex neutral hiring processes, or promoting deferential treatment of or providing special benefits to individuals on the basis of race, sex, color, or ethnicity. There are also a couple of different places. These basically say essentially the same thing, but there are a couple of other executive orders. One, combating race and sex typing. It defined what they considered divisive concepts that include one race or sex is inherently superior to another race or sex, that the United States is fundamentally racist or sexist, that an individual by virtue of his or her race or sex is inherently racist, sexist, or oppressive, whether consciously or unconsciously. And another, ending radical indoctrination of K through 12 schooling. The executive order talked about discriminatory equity ideology. And again, so members of one race, color, sex, or national origin are morally or inherently superior to members of another. An individual by virtue of the individual sex, race, color, sex, or national origin is inherently racist or sexist or oppressive. If you read these executive orders, you really get a sense of what, I mean, it's once you get over like the language can be a little bit forceful, but when you read it, you get a sense of what they're going to be looking at. And actually, after we prepared the slideshow, the slide deck, the EEOC did issue some guidance that you should take a look at. There are two different things. There was a what to do if you experience discrimination related to DEI at work. And then there's another document that's essentially a question and an answer, a FAQ about what should you know about DEI related discrimination at work. And I think if you look at the FAQs, it at least it gives somewhat of a roadmap of what they might look at, what one of these agencies might look at if they're coming in and either there's been a complaint that you have illegal DEI practices, or there's some sort of compliance complaint that's a review that's opened up related to your nonprofit. And what some of the things that they highlight is you need to look at to ensure that there's not disparate treatment in hiring, firing, promotion, demotion, compensation, fringe benefits. I think that's pretty self-explanatory, but some of the others, access to or exclusion from training, including training characterized as leadership development programs. So what you really need to do is let's say if you have ERGs, you have employee resource groups, you need to make sure that those groups are open to all. And not only are the groups open to all, but the programming that's provided through those groups is open to all. That's going to be a focus moving forward. Access to mentoring, sponsorship, or workplace networking, similar. If you have internships, selection for interviews, including placement or exclusion from candidate slate or pools. I think if you are with the rescission of the previous executive order, if you do have placement goals or slates or slates that certain diversity goals that you have to have on the slates of folks that you interview, those are going to very much be under scrutiny if this is looked at by an agency. And then one other executive order moving on from that is ending radical and wasteful government DEI programs and preferences. And so the executive order that was signed around the same time as the other one we were talking about, so the Director of Office of Management and Budget was to coordinate the termination of all discriminatory programs, including illegal DEI and diversity, equity, and inclusion and accessibility mandates, policies, programs, preferences, and activities in the federal government under whatever name they appear. Again, it's a little vague, but we certainly saw a lot of action after this came out to look at that's related to the specific grants that were coming from the federal government to identify which ones would be terminated and which ones wouldn't.
I think the bottom line though, and Jonathan, correct me if you think I'm wrong about this, but with regard to employment, I mean, we have Title VII already. So Title VII prohibits discrimination in employment on race, color, national origin, sex, and religion. And so this is basically, so for example, the EEOC guidance on illegal DEI programs really was talking about violations of Title VII. Jonathan, would you agree with that?
Yeah.
Okay.
I would.
And, and I think it just clarifies that, with these ERG programs, with programs that might be exclusionary in some regard, that they really can't be any. If you were able to have them as exclusionary programs, which I don't think you were, but this is a clarification that you shouldn't be doing these anymore. So you really should be, as Jonathan said, looking at your ERG programs, looking at all programs that you have for your employees and staff, and making sure that there is no restriction on who can participate.
Yeah, that's right. And I think some of the things, so again, I think we all, the hiring and firing, promotion, demotion decisions, that's very clear. Some things that aren't quite as clear that you'd still want to look when you're doing this internal audit, just to ensure that you're compliant with federal non-discrimination laws so just speaking of compensation, right? So I think what we can expect to face probably more scrutiny than perhaps in the past is, say, if you had some sort of diversity statements in your or like during your annual reviews, if you're required to show what DEI efforts you undertook, and if that factored into your compensation, this administration would likely take the view that that's a violation. They've also talked, when you're just talking about, let's say, if you offer training to your employees, it seems likely that this administration is going to take the view that, like if we go back to this slide here, if part of that training talks about, let's say, what they would consider one race being inherently superior to another race, or that the United States is fundamentally racist or sexist. Not certainly, I don't think any of your programs have that language, but you can see what they're getting at. So they're likely going to be scrutinizing your training as well. So you've seen there's been a focus on anti-racism. There's like certain language is probably going to trigger a closer scrutiny of your training, because they've given the indication, and if you read that FAQ from the EEOC, that if they think that the training that you're providing your employees violates what they consider illegal DEI, then they're going to say that you're creating a hostile work environment. So it's just, there's a lot of things that you might not think that this touches on that it does. And let's move on to some other notable executive orders and actions.
Okay, so so these are fun. So the first one was this temporary pause of grants, loans, and assistance programs. And so there was a memo that purported to require every federal agency to temporarily pause any agency activities. And so that probably caused many of your clients, and certainly for our clients, great concern, where they were going to actually pause all federal grants and loans. There were 2 preliminary injunctions that were issued in both DC and Rhode Island, freezing that, basically saying, hey, you can't, we had, organizations had contracts, they had grants in place, and basically you can't pause those by fiat. If you want to pause those grants, if you want to amend those contracts, you need to do it on a case-by-case basis. So right now, we've got the temporary injunction in place. We are seeing, though, agencies coming and canceling contracts now on a contract-by-contract basis. So you can expect that. The next one was the reduction of indirect cost reimbursement rates for research institutions. This is the F&A rate. Now, this was a big deal for us. I don't know how many of you on this webinar, if your clients or organizations have this issue, but this came on February 7th at 6 or 7 o'clock at night. It was a Friday. This administration, these agencies have decided to drop a lot of these on Friday nights. I think it's just a bit of a scorched earth campaign that they have right now. It's kind of difficult to manage, but what they did was they imposed an across the board rate cut. So institutions, when they have a grant or a contract with the federal government for research, they negotiate the F&A rate, and it's based on actual expenses. So this is overhead, it's maintenance, it's utilities, it's administration support, security, insurance, things that the federal government will not let us include in direct costs. This is different. You'll see that the F&A rates with foundations may be lower. It's not necessarily because the costs are lower, but because they might allow institutions to include different costs in those direct expenses. So anyway, at 7 o'clock or so on Friday, February 7th, NIH announced that they were limiting the F&A rate to 15%. So for many institutions, Emory included, that had rates in the 50s or 60s, this was going to be a huge hit. And not only was it going to be, did it come out Friday at 5, 6, 7 o'clock, it was going to be implemented beginning Monday morning. So by Monday morning, 2 lawsuits were filed. There's a nationwide preliminary injunction on this as well. And so we will see where this ends up going. But again, this was one of those things that would have been negotiated. I mean, each institution had negotiated this rate. So this was something that they said you just cannot do by fiat. The ban on transgender athletes in women's sports. Jonathan, you want to talk about that one?
Yeah, sure. So this is one of those where I think that the language of the executive order was aimed at as much as like signaling where this administration is going than most. But it stated that, so the executive order stated that there are only two sexes, male and female, and that they're determined by immutable biological factors at conception. It also directed the federal government to interpret and enforce Title IX under the sex definitions provided in a previous executive order, which would bar transgender women and girls from competing in women's sports. There's a lawsuit that's been filed challenging this, but we've just seen that. Is it Columbia, Mindy? I think it's Columbia, where they threatened over $100 million in funds because they have a transgender athlete. So
Oh, was it Penn? I think that was Penn.
oh, Penn, I'm sorry, at Penn.
The president's alma mater. Yeah.
Yeah. So the president's alma mater. So this is certainly, and this isn't a surprise from the campaign trail, that this is going to be one of the focuses of this administration as well. And then we talked about, Anton did a great job talking about immigration, and he talked specifically about this EO, about immigration enforcement against places of worship in schools. So we won't talk about that. But it was also the Department of Education put out a Dear Colleague letter banning DEI related programming. So essentially, for those who work in a school system, you know this already, but I'll try to be brief. But the Office for Civil Rights is the organization that's charged with really Title VI and Title IX enforcement. And they released Dear Colleague letters to basically state what their position is on certain topics. And so on Friday, February 14th, they published at
7:00 at night.
Yeah,
so,
7:00 on Valentine's Day. They released a Dear Colleague letter announcing the intentions for enforcing the Supreme Court's decision in Students for Fair Admissions versus Harvard, which bans race-based affirmative action, although the letter itself was applied SFFA much broader than the actual case itself. Now, they came out with FAQs later that really kind of that it wasn't quite as jarring, and it really kind of it was more in line with what we've seen from the courts in Title VII and Title VI. But that's also that DCL is a good reference place to see where they're going to focus their enforcement actions.
Yeah, I think, with that Dear Colleague letter, it really, so we talked about Title VII. Title VI is for federally funded institutions, federally funded organizations, and it says they can't discriminate on the basis of race, color, and national origin. And what that Dear Colleague letter did was basically kind of restate that in sort of the most, at least a person who practices in this area, sort of aggressive terms possible. And so, on the one hand, yes, we know it basically reiterates that Title VI is it needs to be complied with, which is fine. But then it really expanded this Students for Fair Admission was about admissions, but they said no, it's about more than admissions. It's really about the whole process. So everything from financial aid to scholarships to administration. So it sort of blew that wide open. And then, as Jonathan then said, the FAQs walked it back a little bit and had it much more measured language. But it is helpful if you want to see where they're going with this concept of illegal DEI to read those. But really, again, it's basically, what we have to rely on is what Title VI, Title VII, Title IX, and just making sure that you're in compliance with that.
Yeah, and I think what that Dear Colleague letter did, and what some of the other enforcement actions that have been opened also kind of highlight is this is your relationship with third-party vendors, right? So if there's if you can't do something under Title VI or Title VII, well, you can't contract with someone to do the same thing. And so in that Dear Colleague letter, it did talk about, third parties during the admission process. And so it's a good thing to look out for that as well.
Yeah, absolutely. And you'll see there was the Office of Civil Rights sent letters to 45 universities stating that their arrangement with an organization that was restrictive on who could be a member or who could participate was in violation of Title VI. So again, I think Jonathan's point is a really good one, is that you need to make sure, if you're a federally funded institution, you need to make sure that you understand which community-based organizations that you're contracting with and whether or not they're exclusionary. There was a lawsuit that was filed by the National Education Association and the ACLU regarding the Dear Colleague letter. There was a motion filed for a preliminary injunction on March 21st, but there hasn't been a hearing held on that one yet. So we'll see where that goes.
So, the original executive order we were talking about, for a little bit there was a reprieve from complying with some of the provisions. So, National Association of Diversity Officers in Higher Education brought a lawsuit against the administration and were successful in getting a preliminary injunction, which paused the termination, certification, and enforcement threat provisions of that executive order. So it didn't ever deal with the previous executive order 11246 and its rescission, but the other pieces it did. And so the district court there found that the termination provision, which was basically the provision that terminated the contracts that might have a legal DEI, they found the vagueness of the term equity related grants or contracts invites arbitrary and discriminatory enforcement. And then the certification provision, they found that on its face, it constitutes a content based restriction on the speech rights of federal contractors and grantees. And then the enforcement threat said it violated the First Amendment because it threatens to initiate enforcement actions against plaintiffs for engaging in protected speech. So there was a while there where there was a preliminary injunction entered that paused the enforcement of those provisions. However, recently, the Trump administration filed an appeal and the Fourth Circuit stayed the preliminary injunction, right? So it's back. So the executive order is back in full force, and the case is still going to make its way through the courts. But the Fourth Circuit ruled that the administration satisfies ground for the stay of enforcement from the preliminary injunction pending the appeal. But in the 10-page opinion, the Fourth Circuit said that on its face, they're limited in scope and that they only target DEI programs that are illegal and violate federal anti-discrimination law. So basically, the court said, look, perhaps when it's applied, if it's applied in a manner that's illegal, then you have an issue. But on its face, it's only prohibiting conduct that is already prohibited by federal anti-discrimination law. So essentially, the effect of that is that executive order is back on the books, and you're expected to comply with it. And so let's talk about some steps to take now to comply with federal law and the DEI executive orders. So, I think a lot of you have probably already taken these steps. And please, if there's something to add, please do so. But so what we suggest you do is that, first you determine whether your institution's a federal contractor with respect to the executive orders, right? Yeah, I'm sure you've already done that. If you're conducting affirmative action pursuant to the previous executive order 11246, you have until April 21st to end those efforts. So if you have affirmative action plans that were based on that executive order, you need to stop doing that by April 21st, although you have to continue to meet your affirmative action obligations with respect to vets and the disabled. Review and catalog your yeah.
Let me say one more thing
Yeah,
about that. So for us, we have provisions in all of our contracts with regard to affirmative action. So all of those have to be updated. You have to notify the vendors. So definitely look at that to make sure that your contract provisions are up to date. If you have materials that have been printed that have anything about affirmative action in them, those need to be updated. You need to look at your websites to see what they say and make sure that those are updated. So and then, as Jonathan said, we're looking at this deadline, and hopefully it will not be as difficult. Your organization will not be as complex as like ours with the multiple schools and the schools going in different directions and having their own websites, and you'll be able to track this down easily. But that's the one thing that you should focus on first.
Yeah, and I would say for say like your job postings, review those, and if you use a third party to post your jobs. A lot of times those third parties will it'll actually just pull your job posting and put it somewhere else. So if you're able to revise your job posting on your website or wherever you post your jobs, then it should accurately reflect on where it's being posted elsewhere. But if you do contract with someone to help, if you have recruiters, you need to make sure you look at your language and revise that. And like Mindy said, I mean, it's there could be a lot of places. So you could, if you can keyword search your website too, for a number of affirmative action, a number of different words, then you should be able to do kind of catalog where it is on your website and see if you need to revise that. But that's really the first thing you need to do, because that deadline's rapidly approaching. Also, review and catalog your DEI programs and assess various risk levels associated with those activities, and if possible, conduct the review under privilege. So, in I think in the perfect world, if everybody had all the time in the world, then certainly if you're able to, as counsel, you should be the one that's directing those efforts to catalog, to identify the programs, and then to assess the various risk level associated with those activities. So, we mentioned before. So, if you have, there's certain things that we know that this administration is going to look at. There's some things that we know from the past that can be a problem in Title VII. So, things such as if there are hiring decisions that are impacted, if there are, if compensation, again, like we discussed earlier, if compensation is impacted by DEI efforts, things like that certainly will be higher risk. Now, whether or not you're, the next one is determine your risk tolerance as an institution, both legal and otherwise. Like, so I'm going to assume that what you're doing is compliant with the law. And so, but there's certain things that might draw attention from federal regulators that might not have done so before. And so you really need to understand what your risk tolerance is for these specific programs. So you've seen a lot of institutions that have gone out and they've changed the name of their DEI offices, or they've taken steps like that, pulling stuff off of websites. You just have to figure out as an institution where your risk tolerance is. And then when you're making decisions, consider your communication strategy. You're going to get questions either way, right? If you continue certain practices, you might have a subset of your workforce that complains about them. If you remove the certain things from your website, then you're going to have another certain segments of your employees that are going to complain about taking those down as well. I think what we've tried to do is if you can be as resolute as possible, that if you've identified what your core values and beliefs are, and you use those kind of as a kind of to more what you're going to do in this process, that helps, because it helps with communication as well. But then you also now just have to take into account whether or not, like, if the if it's worth it to the organization to potentially not have as much scrutiny from the federal regulators by removing some things from your website or changing names or just changing the way that you message things. So they're not easy answers here, but it's important to do that. And it's important to have that conversation if you haven't already now, so that if you're forced to do so, if you get a letter from a government agency questioning whether or asking about a relationship with maybe a third party vendor that you've already known about that. And so you have a communication strategy and you kind of know where you stand. So it's not a fire drill at that point.
Yeah, and someone asked, should each organization eliminate the word diversity from its policies? And I think Jonathan did a really good job basically answering that, not necessarily, but you should be aware of how it's being used and make sure that that you're okay with it, both from a legal standpoint and a risk tolerance standpoint. So, for example, you have language on your website or policies that say, we will ensure that we have hired a diverse, that we have a diverse group of employees or something like that. That makes it look like you have some sort of targets that you're looking for as far as who you're planning on hiring and potentially if you're doing that by race. So you just want to go through and see how diversity is being used. I mean, we wouldn't think that you would need to go through and take it out everywhere, but it may need to be changed in some places. And as Jonathan said, like titles of programs, you might consider changing some of the titles, not because they're necessarily the program itself is not necessarily problematic, but the title might draw attention to you in a way that you don't want attention at that point.
Yeah, I think that's
So,
right. I mean, diversity is not it's not illegal, right? Diversity, equity, and inclusion is not illegal. But now we're in an atmosphere where there's a lot more scrutiny on your program, so you need to make sure that those are compliant. And like I said previously, like if you have affinity groups, or employee ERGs, like just go through and make sure that there's that open to all language, right? And not just that it says that, but that's actually the case. Or you can use their allies language, and their allies, just so that what it says on your website accurately reflects how it works in your organization. Because we're in and this has been the case for a while now. There are going to be a lot of complaints that don't necessarily come from somewhere within your organization or anyone who's even ever dealt with your organization. It's someone who's in a different state that's looking at your website and filing a complaint, because anybody can file a complaint and then you get notice of it. So, it's all of those forward-facing communications. It's a good time to really look at those.
and the possibility of there being a False Claims Act claim then because of these statements that you may have been signing with regard to grants or contracts. Okay, someone asked, are obligations the same for the grantee as they are for the contractor? So yes, I think. Okay, so now the agents, if you have a federal grant or federal contract, they will flow through the terms to the organization, to the nonprofit organization. You should be flowing those terms through to your grantee as well. So if that answers that question.
And I see this. I'm sorry.
Oh yeah, and then you can go ahead.
So yeah, this is a really good question. Do you think saying you are an equal opportunity employer is dangerous? I do not. You are an equal opportunity employer, but what you need to look at is your affirmative. So your affirmative action language, right? So you also still have affirmative action requirements related to vets and disabled employees. But if your affirmative action says, and you can, a lot of times the affirmative action language actually mentions EO 11246. So run a search for that on your website, but also in your contracts, And if that's the case, then you need to remove that and you need to revise that language. So I don't think it's dangerous to have equal opportunity employee because you still have equal opportunity. You still have EEO requirements. Well, and depending on the size, those might vary, but I don't think just that itself is, but you do need to look at your affirmative action language. Any other questions? This is what I do on a Zoom CLE. I talk as fast as I could possibly talk. And I could go through 1,000 slides in about 7 minutes. You know, we might have to end it here a little early, but any other questions?
If anyone has any other questions, you can put it in the chat, you can message us. But you know, it's a lot, right?
Mhm.
And it really is just, I mean, if you can break it down as the affirmative action part and then Title 6, 7, 9 and look at it from those perspective, I think that's helpful. You know, I think it's helpful to do these word searches looking for diversity, any kind of terms on race, any kind of the terms on gender, just to see how they're used. And it doesn't mean that you have to eradicate them. You just need to be aware of how they're being used.
Agreed.
Okay.
All right. Well, let's see. Okay. Yeah, here we go. All right. What would you say about a nonprofits program that is funded by a federal grant, where their grant itself has diversity emphasis and the federal grantor has not yet changed the terms of the grant?
Well, I think you're going to be, I mean, we're seeing this week we've started seeing terminations of grants that have DEI, that the nature of the grant was diversity, and we're seeing them start to be terminated. So I think I'd be prepared.
Anyone else?
And either that or they're going to come back and ask for some sort of certification that it's not for diversity, and you're not going to be able to state that.
Great point. All right. Well, I guess that's it. Anything? Okay. Thank y'all so much. Yeah, this is a lot and it's hard to, I do think it's important when you're talking to your internal clients. What I try to remember is just that, you know, a lot of times we're lawyers, so we're looking at the law and what we have to solve and what we have to worry about. But I think it's important to kind of, obviously everybody's doing this, but to kind of step back and check in on the people that you're talking to about this, because a lot of folks that you're working with on some of this work, that might be the majority of what they do. And it's important stuff. So thank y'all, and we'll
And
give you.
Jonathan, there's one more question in the chat. We'll grab
Oh,
that.
yeah.
Someone asked about how this impacts affiliation with HBCUs. As long as HBCUs allow students, no matter what their race, then I think it's okay. I don't think they're not restrictive, so it should be fine.